actually a nice lead into something that I want to start with before my actual talk, which is that the emphasis for celebrating Gault's 40 came a lot from the National Juvenile Defender Center. And a couple of weeks ago, the National Juvenile Defender Center had its annual summit, where there's, this time even more, but usually around 250 juvenile defenders all sitting in rooms together talking about the sorry state of affairs and ways that we can change it. But because this was the anniversary of Gault, as one other time at one of our conferences, they had invited Gerald Gault to be there. And so it was really nice seeing Gerald Gault and getting to talk to him. This was my second time meeting him. And so I really had a nice conversation with him and his wife. And I told him about the project that we were doing here in Houston and how we had gone out to the schools, and he was really excited about it and very pleased that the school kids were really understanding the importance of right to counsel, which you heard in the little video where the child was saying, a parent's not good enough, you need an attorney. An attorney is the one who can help you. And he told me that if we got this grant that we're still waiting to hear about, and we have the opportunity to bring the 400 plus children that we've already reached out to, plus some more, to the Law Center to do some mock trials and talk again about the importance of counsel, that he'd be very happy to come out here and meet the children, because to him that's really important. And he told me that he had been to Houston one other time. And this illustrates how there are definitely differences between children and adults, but I don't know that it's always that adults are so much more competent and well prepared than children are. But he came here because a group of school children were getting together and doing a history project for a national competition. And the parents got together and paid for him to come to Houston to help them with this project. And they spent days interviewing him. They made a videotape. They had this whole wonderful presentation put together about Gerald Gault and his case and the right to counsel. And they went off to this national competition and put their entry in. And they were told by a panel of adults that were in charge of judging this competition that they could not have gotten all that information from a person because Gerald Gault wasn't real. That's what they said. He was outraged, and he just wished that the kids had called him from the national competition because he would have gotten on the plane and shown them how real he was. But they were a group of adults who specialized in this area of history and didn't realize that people in Supreme Court cases were real. And Gerald Gault was certainly real. So I'll tell you a couple of more stories as I'm going through my talk, because I think that Gerald's experiences and the way that he talks about it is actually very important to understanding Gault itself. And what I'm going to focus on during my time up here is the right to counsel that children were granted under the Supreme Court decision in Gault. And historically, as Professor Rosenberg talked about, the right to counsel has been there for adults in criminal trials. The Sixth Amendment granted it for all federal criminal prosecutions, and through a series of cases, the courts did give it to adults incorporated under the 14th Amendment and the Sixth Amendment. But it started in 1932, where the Supreme Court looked in Powell v. Alabama, and they stated that the right to be heard would be in many cases of little avail if it did not comprehend the right to be heard by counsel. Even the intelligent and educated layman has small and sometimes no skill in the science of law. If charged with crime, he is incapable generally of determining for himself whether the indictment is good or bad. He is unfamiliar with the rules of evidence. Left without the aid of counsel, he may be put on trial without a proper charge and convicted upon incompetent evidence or evidence irrelevant to the issue or otherwise inadmissible. The court went on to say that if that's true of men of intelligence, how much more true is it of the ignorant and illiterate or those of feeble intellect? And certainly, you can include in there children. No matter where their intellect is, they're still at a very different developmental level and certainly could not maneuver the legal maze of a trial on their own. But this was done under 14th Amendment due process, looking at the state's need to provide the right to counsel. In Betts v. Brady, the court also found that the state had the need to appoint counsel, but only in special circumstances, where the trial was offensive to the common and fundamental ideas of fairness and right, taking into consideration such factors as the length of the sentence, the complexity of the charges, and the defendant's ability to represent himself. The Betts decision also supports the idea that children are entitled to right to counsel in delinquency proceedings, even though they're not considered criminal. Okay? That as the child is facing the possibility of confinement, the trial has complex legal issues, and certainly the child, again, lacks the ability to present his or her case to the court. 4 years prior to Gault, the court looked at Gideon v. Wainwright and held that defendants charged with felonies in state court were entitled to counsel since precedents, reason, and reflection require the court to recognize that in our adversary system of criminal justice, any person hailed into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. The right of one charged with a crime to counsel may not be deemed fundamental and essential to fair trials in some countries, but it is in ours. And Gideon incorporated the Sixth Amendment and applied it to the states. And as Professor Rosenberg discussed, Gault took a different point of view. They didn't look at the Sixth Amendment right to counsel in that case, but instead went back to looking at due process fundamental fairness. Part of the reason for that was the court's acknowledgement of the fact that juvenile matters were considered civil, and the Sixth Amendment applies to criminal cases. The court also looked at the original purpose of the juvenile court, and that it was founded on the belief that society's role was not to ascertain whether the child was guilty or innocent, but what is he? How has he become what he is? And what had best be done in his interest and in the interest of the state to save him from a downward career? The child is to be treated and rehabilitated, and the procedures from apprehension through institutionalization were to be clinical rather than punitive. So on this basis, the court was looking at due process fundamental fairness. But they also did recognize the similarity between juvenile trials and criminal trials. They said a boy is charged with misconduct, the boy is committed to an institution where he may be restrained of liberty for years, and it's of no constitutional consequence and of limited practical meaning that the institution to which he is committed is called an industrial school. As Professor Rosenberg reminded us, Gault was given a 6-year sentence in what was an industrial school, but was still in youth prison. The court went on to say that in view of all of this, in view of the similarities between the courts and still the uniqueness of the juvenile court, it would be extraordinary if our Constitution did not require procedural regularity and the exercise of care implied in the phrase due process under our Constitution. The condition of being a boy does not justify a kangaroo court. And many people, when they read Gault, this is great. Now children are going to have some constitutional protections. The court is giving that to children. And the rationale that the court used in appointing, making sure the counsel was going to be appointed, again, was that 14th Amendment due process. But they also used the rationale that was illustrated in many of the criminal cases. So they said that juvenile needs the assistance of counsel to cope with problems of law, to make skilled inquiry into the facts, to insist upon regularity of the proceedings, and to ascertain whether he has a defense and to prepare and submit it. The child requires the guiding hand of counsel at every step in the proceedings against him. By balancing the competing interests of the juvenile court, the unique aspects of juvenile proceedings, the ability to see the child as a child, the preference for individualized treatment against the reality that the process and the end result were very similar to criminal court, the justices recognized the need to provide children with counsel in these proceedings.